Joining us today. I'm Jackie Unger. I'm here with my colleague Ryan Boonstra, and our presentation today is on managing the financial impact of tariffs on your government contract. Can we go to the next slide? So I'm Jackie Unger. I'm the chair of PilieroMazza's Government Contracts Practice Group. I'm also co-chair of the firm's False Claims Act group. And a little bit about me here on the slide. I help contractors navigate doing business with the federal government, including advising on disputes with the government and teaming partners, counseling on FAR and small business regulatory compliance issues. I litigate bid protests and size and status protests, and I also handle False Claims Act investigations, among many other things that I deal with in the government contracting world. And now I'll hand it off to Ryan to introduce himself.
Yes, as Jackie mentioned, my name is Ryan Boonstra. I'm an associate here at PilieroMazza, also on the government contracting team. The majority of my practice focuses on requests for equitable adjustments and certified claims under the Contract Disputes Act. I do assist in some bid protest matters as needed, and I have some experience with developing small business subcontracts and helping represent subcontractors on their prime contracts. And that involve government contracting projects. I also have a little bit of unique experience related to weapons development and research from my time at the Navy Yard in Philadelphia. And I'll hand it back to Jackie to tell everybody a little bit about our firm.
Thanks, Ryan. So here's a little bit about our firm if you're not already familiar with PilieroMazza. We serve as a strategic partner to our clients. We've got our government contracting space, but we also practice in the areas of business and transactions, labor and employment, litigation and dispute resolution, and construction. So if you're not already and you're interested in staying up to date on recent developments in these areas, you can sign up for our newsletters and blogs at our website that we have listed here, PilieroMazza.com. Good way to stay up to date on industry developments. And then lastly, attorney disclaimer, I want to note that this webinar is for general informational purposes only and does not constitute legal advice or give rise to an attorney-client relationship. So now that we got that out of the way, let's turn to our objectives with today's webinar. So I want to start with a brief overview of what we'll be covering today. So we're going to talk a little bit about the current state of tariffs. We've had a lot of changes in the Trump administration, so we'll give a high-level summary there. And we'll talk about how to navigate FAR clauses that are relevant to tariffs and their cost and schedule impacts. We'll talk about some strategies for mitigating the risk that tariffs present. And then we'll discuss strategies for seeking relief through requests for equitable adjustment, which is REAs, and certified claims. I do want to note that there is an ability to ask questions. There's a question box. We have a lot of material to get through today, so if we aren't able to address them in the moment, we will try to get to them at the end. And then if we don't have time for that, then we will follow up with you to try to answer your questions as best we can. So with that, to kick us off, I'll turn it over to Ryan to talk a little bit about the current state of affairs with the various tariffs we're seeing.
Sure. Thanks, Jackie. So really the question is, where did this all begin? And it goes back to the beginning of 2025, which, believe it or not, we're already in October of 2025. Most of these tariffs that made the news came out when President Trump began issuing executive orders at the beginning of 2025, primarily in February. But since then, these tariffs have changed. They've expanded. Some have lessened in scope, and several of them have been the subject of international debate at the U.S. court level and the international court level. Right now, some of the noteworthy remaining tariffs for the three primary countries are Canada still has a 10% for energy and energy resources, and potash, which is potassium bearing minerals for anybody unfamiliar, and that is essentially is used in fertilizer and the manufacture of soap, glass, and ceramics. 35% at Canada for all other products, unless it's under the United States Mexico-Canada agreement. And that includes provisions on market access, digital trade, intellectual property, labor and environmental standards, and dispute settlements. China still has 10% on all goods currently. A 35 or 34% tariff has been looming over China, but is currently delayed as part of an ongoing agreement until November 10th. That agreement was just extended. It previously was set to expire last month. There is also a 20% tariff in China to combat the fentanyl crisis, which is currently on appeal, and we'll get into a little bit of that later. And most recently, there is now threatened an additional tariffs of up to 200% across various different industries with regards to China. Mexico has simplified the amount of tariffs quite a bit since they were first announced at the beginning of the year. Right now, it's just on a 10% for potash and 25% for all products that are not under the United States-Mexico-Canada agreement. Now, these three countries were the primary focus at the beginning of the year, but since the beginning of the year, there's also been numerous global tariffs that have been announced. Currently, there is a 10% baseline tariff for all countries that are not covered by an exemption. We could get into the exemptions, but it would occupy our entire hour here. So it's important that if you have a government contract that involves importing goods from specific countries, that you stay up to date on that specific country's exemptions and how it will impact your shipping needs. Generally speaking, there's a 50% tariff on steel and aluminum from all countries. The UK is accepted out of that at 25%. The United States Mexico Canada agreement also counts as an exemption, and Russian origin steel and aluminum is now up to 200%. There's a 50% tariff on copper, with the EU and Japan aerospace being exempted, and anything that counts as a copper derivative being exempted. 25% on automobile and automobile parts. Again, we have exceptions for the EU and Japan, as well as the UK. And then 10% for lumber and timber products and their derivatives. And this is a big one that people are monitoring, because right now, unupholstered wooden furniture is at 25%, but that's set to increase to 30% going into 2026. And kitchen cabinets and vanities, which is very specific, but it's currently at 25%, but is set to increase to 50% in 2026. Now, there's also been numerous new threatened tariffs headed into 2026, and a lot of those come out of what you'll hear referred to as Section 232. And these are tariffs that are designed to protect national security. But heading into 2026, it's been announced that certain pharmaceuticals and personal protective equipment, or PPE, will now fall under Section 232. And so those will be some new tariffs that may pop up as we head into 2026. In addition to what a lot of other people will hear is Section 301 tariffs, which is additional taxes and duties that are imposed from particular countries that the US believes are violating trade agreements or engaging in unfair trade practices. And so those Section 232 and Section 301 are a little bit separate from the executive order tariffs that have been making the news. They just get updated as the investigations each year or each quarter take place. And so it's always important to pay attention to those. Now, as I had mentioned previously, the tariffs have led to widespread public discourse and different challenges at both the United States court level and the international court level. Most recently, in VOS Selections Incorporated versus Trump, the Federal Circuit affirmed the Court of International Trade's holding that fentanyl and reciprocal tariffs exceeded the president's authority under the International Emergencies Economic Powers Act which is what he used to justify those tariffs in his executive orders. They also affirmed the declaratory relief that fentanyl and reciprocal tariff executive orders were invalid as contrary to the law. And the Federal Circuit vacated the permanent injunction that universally enjoined the tariffs enforcement in order to remand it back to the Court of International Trade to further evaluate the scope of the injunctive relief. And one of the primary reasons for this last part of that holding was the Supreme Court had recently decided in Trump versus CASA that the issuance of a universal injunction is likely to exceed the equitable authority that Congress has granted to federal courts. So not only is there a question outstanding as to the enforceability of the tariffs, but there's a question outstanding as to what can be done to combat or impose the tariffs. So there's a lot of new law that's being developed as a result of all of these tariffs. And in the meantime, while all of this is ongoing, there's also been a 40% transshipment penalty that's been put into effect through Executive Order 14326. And this allows the U.S. Customs and Border Protection to determine whether an individual or a company is attempting to evade the application of tariffs by transshipping. And what that is the process of transferring goods from one mode of transportation to another form while they're being transported, whether they're imported or exported. And that impacts the analysis as to whether a tariff is imposed on that form of transportation. And so now there's a 40% penalty that people need to be on the lookout for. And then there's also been some increased scrutiny under the False Claims Act, which I know Jackie has some information she's going to discuss on the Trade Fraud Task Force that's recently been created.
Yeah, so recently in August of this year, DOJ and DHS announced the formation of this Trade Fraud Task Force, which is really meant to prioritize enforcement focused on tariff evasion. So it aligns the efforts of DOJ's civil and criminal divisions, Customs and Border Protection, and Homeland Security investigations to enhance enforcement against importers and other parties that seek to evade tariffs and other duties or smuggle goods into the U.S. And engage in any other import-related misconduct. So this is really front and center priority for DOJ right now. DOJ has announced that the task force will bring enforcement actions under a number of different statutes, like the Tariff Act of 1930 and the False Claims Act, as well as pursue parallel criminal prosecutions and penalties as appropriate. So I just wanted to call this out. Under the False Claims Act, the government, as well as third-party relators or whistleblowers, can pursue claims against importers that knowingly avoid paying duties to the U.S. government. And in the customs realm, this generally involves importers understating the value of imported goods to reduce customs duties or misrepresenting the origins of imported duties, or otherwise miscategorizing imports for customs purposes. And there's really serious ramifications for FCA violations, including treble damages. And whistleblowers can bring claims on behalf of the government as well. So it's a really powerful tool that this task force has. And we just wanted to bring your attention to the increased scrutiny here and the importance of making sure that you understand when the tariffs are owed and not trying to evade those tariffs. Okay, so Ryan, thanks for that background on where things stand with tariffs. So now I want to turn to mitigation strategies. So what can we do to deal with increased costs that we're facing due to all of these various tariffs? So there are a number of avenues that contractors can pursue to limit the impact of tariffs. Number one, start with your contract. And the first aspect of that, since certain FAR clauses can provide relief, the first aspect would be to look for exemptions to avoid paying tariffs in the first place. If there are no exemptions, then you can look for contract terms that permit recovery of costs that are incurred from tariffs. And there are also avenues for relief from delays if you have trouble meeting your schedule due to supply shortages or disruptions due to the tariffs. So we're going to be talking about all examples of these FAR clauses. You should consider negotiating with the contracting officer to add these clauses into solicitations up front to make sure that they're in there for your protection. And you can also try to negotiate to get them added to contracts where they're missing. So second, be conscious of your supply chain. You can consider shifting your supply chain to decrease reliance on foreign materials that are impacted by tariffs. Understanding this is difficult to do when we're seeing a lot of back and forth and changes in the tariffs. It's hard to know whether unsustainable tariffs will actually remain in effect with the legal challenges as well. But that's to the extent that you can move your supply chain where the tariffs are lower or bring them into U.S. Manufacturing, then you can avoid them altogether. And then lastly, factor in increased costs and risks into your proposal if you don't have the ability to get an exemption from the tariffs or if no other relief is available. But it's really important to note that you cannot recover under some of the clauses that we'll be talking about if tariffs are included in the contract price. So you can't include them in your proposal, but then also get an exemption from them and then keep that amount that you ended up not having to pay, but the government has paid you. That effectively increases your profit, and that wouldn't be allowed. You would have to not include the cost in your proposal or return that amount to the government. Okay, so let's dive into some of the specific FAR clauses that can provide relief. So first, you should consider whether it's possible to get an exemption from the application of tariffs when the products are imported. So there are two FAR clauses that provide for duty-free entry. There's the basic FAR clause and a DFARS clause that's applicable to DoD procurements. So one or the other of these clauses is supposed to be included in contracts for supplies that fall under a harmonized tariff schedule heading that grants duty-free entry or that otherwise allows for a potential tariff exemption. So the list of articles that are not automatically entitled to duty-free exemption, but which might qualify for an exemption, is somewhat limited. So that includes materials under the Strategic and Critical Materials Stockpiling Act, plant seeds and other planting materials for the Department of Agriculture, supplies for a government-operated vessel or aircraft, and food, clothing, and medical, surgical, and other supplies for use in emergency relief work when there's a national emergency. But it also includes, so those are kind of limited circumstances, but it also includes articles for NASA, source materials for the Department of Energy that are necessary for national security and defense, and materials for DoD where the procuring agency certifies that the articles are to be emergency war material purchased abroad. So there's it's supposed to be a determination that's made by the procuring contracting officer whether the supplies that are at issue under the contract are eligible for duty-free entry or for an exemption from the tariffs on this list. So, and there's some, you can have that negotiation with them about whether these clauses should be included in the contract. So then for the basic FAR clause 52.225-8, this is for supplies that are not entitled to automatic duty-free entry in the schedule. This clause provides that contractors must work with the contracting officer to get an exemption, again, if the supplies are entitled to an exemption. Contractors are required to notify the contracting officer in writing at least 20 days before importation of any purchase of foreign supplies over $15,000 that are to be imported either as end products or for incorporation into end products. This notice is not required if the foreign supplies being purchased are identical to items that the contractor uses in its commercial business as well, and it isn't able to economically or feasibly segregate those supplies to be able to tell which ones would be used on a government contract and therefore would be entitled to duty-free entry versus the ones that would be used on its commercial business side. But if that exception to providing notice doesn't apply, then this notice is required to work with the CO and get the exemption. So the CO, after you provide the notice, will then determine whether the supplies should be accorded duty-free entry, and they will provide any required duty-free certificates and help the contractor basically in obtaining the duty-free entry. Again, I want to note that the contract price must not include the cost of the tariff duty, or if the price of duties was included and an exemption is obtained, the contract price will need to be reduced. I want to note here that contractors can only claim duty-free entry for supplies to be delivered to the government under the contract and must still pay duties on supplies diverted to non-governmental use. So that's why it's important to be able to segregate which supplies are going to which purpose, government purpose versus non-government purpose. So then on the other side here, we have the DFARS clause. It works a little bit differently. So when the DFARS clause is in your contract, it provides that unless the supplies are entitled to duty-free treatment under the harmonized tariff schedule, or the contractor has already paid the duty, then DoD will issue duty-free entry certificates for qualifying country supplies, whether those supplies are end products or components. And qualifying countries are basically 28 different countries that have entered into reciprocal defense procurement agreements with the US. It generally aligns with the list of designated countries under TAA, but not quite the same. So let's see, in addition to those qualifying country supplies, you can get a duty-free entry certificate for eligible products, which would be end products, but not components, under contracts that are covered by the World Trade Organization Government Procurement Agreement or a free trade agreement. So basically when TAA applies, the Trade Agreements Act. And then it also covers other foreign supplies for which the contractor estimates that duty will exceed $300 per shipment into the customs territory of the United States. So there are a few different ways that this clause can be invoked. The process is kind of convoluted when you use this clause. Obtaining the exemption requires the contractor working with its customs broker, the contracting officer, Customs and Border Protection, and DCMA, which ultimately processes the duty-free entry certificates. Again, the contract price must not include the cost of the corresponding tariff duty, or else the contract needs to be adjusted downward so the government can realize the price savings. The contractor doesn't get to realize those price savings. The DFARS clause outlines the information that needs to be provided to the contracting officer in order to get the certificates. And under this clause, DoD can issue a duty-free entry certificate for a contractor or for any tier subcontractor. And the clause is a mandatory flow down in subcontracts that are for qualifying country components or non-qualifying country components where the duty will exceed $200 per unit. So it's very important to pay attention to what are your subcontractors providing to you, and are you making sure that you've flowed this down so that to enable them to get duty-free entry certificates when that possibility is available to them. All right, can we go to the next slide? Okay, so for cost reimbursement type contracts, this FAR clause, FAR 31.205-41, which covers taxes, likely does provide for recovery of tariff costs. The clause doesn't directly address tariffs, but it likely applies to them as a tax that's covered by the clause. The clause provides that the cost of taxes are generally allowable unless they're specifically identified as unallowable. So for example, the tax costs are unallowable if an exemption is available to the contractor or the government. So this means that contractors need to utilize the exemptions that I was just talking about. You can't pass through the tariffs and have the government reimburse those if they could have been exempted, but the contractor failed to obtain the exemption. The clause requires the contractor to credit the government for any taxes that were allowed as contract costs and that are refunded to the contractor. So if you happen to get reimbursed your tariff costs and then get a refund, you didn't need to credit the government for that amount. Okay, moving on. So the next clause that we have here is FAR 52-229-5, federal, state, and local taxes. So this clause is required to be included in solicitations and contracts if the if the contract is to be performed in the United States, if it's a fixed price contract, and it exceeds the simplified acquisition threshold. The clause provides that the contractor may be entitled to an increase in the contract price for after imposed federal taxes that the contractor is required to pay. So this clause may eliminate the risk under at least some fixed price contracts. However, of course, there are some potential limitations. So the first one, there have been some Board of Contract Appeals cases that have noted that this clause is not mandatory in commercial item contracts. Instead, the mandatory commercial item tax clause is the one that is in the commercial item FAR provision, 52-212-4. And that states that the contract price includes all applicable federal, state, and local taxes and duties and does not contain any language permitting a contract adjustment for tax increases. So for commercial item contracts, it is not mandatory that this clause be included in your contract. You may be able to negotiate that with a contracting officer, and try to advocate for it, but it is not necessary that it be in there. There is some ambiguity over whether the clause applies to tariffs, since it doesn't specifically use the term tariff, but it seems likely that tariffs will qualify as a duty under the clause. As I noted, it's only included in contracts that are performed in the United States. So if all of the work under the contract is to be done entirely overseas, then this clause won't apply. And then the clause only governs new or increased taxes taking effect after the contract date, or tariffs that were exempted or excluded on the contract date, but whose exemption was later revoked or reduced during the contract period. So you have to pay attention to the timing of when the taxes go into effect. Another potential difficulty is that the increased costs must result from a tariff that the contractor is required to pay or bear. So the government potentially could push back on providing a price increase under this clause for tariff costs that the prime contractor does not directly pay. For example, if a subcontractor or supplier pays the tariff cost. So if you're the prime contractor, you want to be able to prove that you bore the cost, or even if you're a subcontractor passing that up, you want to be able to show that you incurred that tariff costs. So ideally, having a line item showing the tariff cost in the invoice from your supplier or subcontractor would be helpful to show that. There's also case law holding that contractors may not recover general price increases that are indirectly attributable to tariffs, like if there are inflationary cost increases of domestic products, that cannot be recovered under this clause. This clause will only apply to the actual tariff costs. In terms of procedure for invoking this clause, contractors need to promptly notify the contracting officer if they reasonably expect a tariff to impact the contract price, and take appropriate action as the contracting officer directs. So ideally, prompt notice would be notice within 30 days of anticipating that increase in the contract price due to tariffs. And then basically you need to work with the contracting officer as they direct. And you also, as the contractor, would need to warrant that you did not account for the after imposed tariffs in the contract price, because again, you can't price that in, get reimbursed for them, but then also, get an adjustment to increase that contract price. Okay, so next slide, please. Okay, I also want to touch on FAR 52-229-6, taxes, foreign taxes for fixed price contracts. So this clause can potentially offer a path to recovery for tariffs imposed by a foreign government that you incur, like if a tax exemption agreements with other countries are removed, or if other countries impose retaliatory tariffs that increase the costs that you face. Under this clause, if the contractor is required to pay or bear the burden of any new or increased taxes or duties, and those costs are due to changes in applicable laws or regulations of a foreign jurisdiction after the contract date again, the contractor may be entitled to an equitable adjustment in the contract price. So the tariff again has to qualify as a duty or similar charge that's imposed by a foreign government. The tariff must be imposed or increased after the contract was awarded, because if it was imposed beforehand, then you are, deemed to be on notice and should be pricing that into the contract. The contractor needs to notify the contracting officer promptly as required under the clause, and the additional costs must be reasonable and directly traceable to the tariff. Okay, for the next clauses that I want to touch on, these are the various economic price adjustment clauses. So if the previous clauses aren't available, and you're in a situation where maybe you are not impacted directly by tariffs, but you have an inflationary effect. So like if the contractor faces increased costs from its domestic suppliers due to secondary market effects, where they are increasing their prices because there's less competition domestically, and so they're increasing their prices because foreign prices are also increasing, then you may be able to recover under an economic price adjustment clause that might be in your contract. And we have the different ones listed here that apply based on the type of contract that you have. So these clauses provide for upward and downward revision of the stated contract price upon the occurrence of specified contingencies. They're included in fixed price contracts at the contracting officer's discretion when it's deemed necessary in their discretion to protect the contractor and the government against what they believe are significant fluctuations in labor or material costs, or to provide a contract price adjustment in the event of changes in the contractor's established prices. So there are several types of economic price adjustment, each with its own contract clause. So you need to determine which, if any of these, are included in your contracts. It might vary from contract to contract. There are strict notice requirements under these clauses. So contractors must provide the notice within 60 days. So it's essential to be on alert for any price increases and to provide that prompt notice to the government to avoid waiving the right to an adjustment. If you don't meet those requirements, you may not be able to get the adjustment. Generally, I think all of the clauses have a cap on the relief that you can get. There's generally a limit of an upward adjustment of 10% of the unit price. So the clause may not provide complete relief if the tariffs lead to major price hikes by domestic suppliers who are increasing their prices. That could end up increasing your costs more than 10%, but you would be capped in what you could recover. So, but at least it's an avenue to get some recovery. All right, and I'm going to hand it over to Ryan to carry on talking about a changes clause.
Sure. So after hearing about all the different clauses that we've just gone through, a lot of people may be wondering, well, why can't I just use the changes clause here? The cost of my contract is going up. I should be able to just claim it's a change. Well, you can attempt to under the right circumstances. The issue with just going straight to the changes clause is it's not guaranteed because of the type of government action being taken here. Tariffs are beyond control of the contracting officer and the agency that is issued and signed your contract. And so while the tariffs ultimately at the highest level are actions of the federal government, it's difficult to make the case that they're a government action that changed the particular scope of your contract. Generally, new laws don't qualify as changes to a contract's requirements. With that being said, there's a potential argument to be made under the changes clause, depending on the circumstances of your case. If the agency instructs or directs or makes you use a specific source for your products that you were not originally anticipating, that either wasn't outlined in the solicitation or wasn't part of your proposal, if your proposal was incorporated into the contract, then the argument can be made that by forcing you to use a certain source, the agency has exposed you to an additional tariff charge. And while nothing else in the scope of your contract has changed, where you're sourcing those items from has changed, and that change has led you to be under the jurisdiction of some of these new tariffs that you weren't able to account for when you were submitting your proposal or your bid. So if you can meet this scenario, then you can go after the additional tariff costs associated with this change, and any other costs by that directive to use a particular source. Other theories and other FAR clauses include excusable delay and non-performance clauses. There's various FAR clauses that speak to these types of circumstances. It'll depend on the type of contract that you're operating under. For example, on this slide, we have fixed price supply and fixed price construction. Generally speaking, the clauses all read almost the same, and they include specific scenarios where there's an avenue to avoid liability for excess costs and impacts to contract performance. One of those scenarios is for the acts of the government in either its sovereign or contractual capacity. So this is what a tariff would more likely count as. Rather than a change, it's an act of the government in its sovereign or contractual capacity. And these clauses outline excusable delays that are beyond the control of the contractor. And these are key if the tariffs are impacting your supply chains to the point where it's impacting your ability to meet a schedule, perform a particular part of the contract, or acquire the supplies and materials that are required by the contract. Now, across these clauses, the notice requirement is key. It is a little different from clause to clause. Some just require prompt notice, some require notice within 10 days. So again, like we had said at the outset, the first step is always reviewing your contract and making sure you have a thorough understanding of the FAR clauses that apply to your contract. This is also a good time to mention that although not every clause we cover today requires you to provide the government with notice, we always recommend giving notice as soon as you're aware of increased prices or delays. And that applies to tariffs or anything else in the performance of your contract, because it cuts off any arguments from the government later that you didn't notify the government in enough time for the government to try and mitigate those increased costs. So notice is always recommended when you know there's an increase in costs coming. And another key point too with excusable delay and non-performance clauses is excusable delay is for time and not money. So this will help prevent any LDs from being imposed. It can act as a defense to any cure notice or show cause notice, or even a threatened termination. That's where excusable delays really have the most important use for contractors. And then one other avenue that is really a option of last resort is the extraordinary contractual relief clause. So just as it sounds, many contractors are not aware of this remedy, and it only applies in extraordinary circumstances. And there's a few requirements. First, you have to have a contract that impacts national defense. And this does not necessarily mean that your contract directly protects or relates to something that protects the country's interests. Various contracts can qualify under the interest of national defense, but it's a case-by-case situation. And it's part of the reason why this clause is so rarely used. The test focuses on the language from the FAR clause that it'll only be allowed when it will impair the productive ability of a contractor whose continued performance on any defense contract or whose continued operation as a source of supply is found to be essential to the national defense. So there is some room for interpretation there and an argument to be made that depending on the circumstances of your contract, just because it's not with the DoD or directly related to some sort of weapons or defensive system, there is an avenue to argue that your contract impacts the productive ability or defense contracting of the U.S. The most recent example where this clause has seen some success is related to national defense contracts impacted by COVID-19. There are FAR clauses that speak towards epidemics and pandemics, but they didn't get into any detail about what the rights of relief were. And not everybody's situations were exactly the same, because some people's contracts were found to be essential and they were required to have their performance continue, whereas their subcontractors weren't found to be essential. And so it created this situation where there was an ambiguity. And so some contractors found success here in the extraordinary contractual relief provision. And we believe that tariffs would be a situation that you could, again, utilize this clause. The other impact or preventative factor for this clause not being available is that it can only be utilized if you've already explored your other options of relief. So if another path to relief is available, such as all the other clauses that we've gone through so far, you have to start with those clauses first before you can move to this clause, which is why it's more of a last ditch effort type of approach to seek equitable relief. And then finally, some of the more commonly known defenses for excusing performance are these legal theories of mutual mistake, impracticability, and impossibility, which have merged, and frustration of purpose. These are similar to excusable delay, but they are centered around your performance rather than a time extension. So the situation isn't government, I need more time. It's government, I can't perform because of these tariffs. These theories all have a very high burden of proof. Mutual mistake requires that both parties were mistaken in their belief regarding the fact of the contract, that belief constituted a basic assumption underlying the contract, that the mistake had a material effect upon the bargain, and that the contract did not put the risk of the mistake upon the party seeking relief. And so each of those is a very high bar to meet, because it speaks towards the material basis for which the contract was made and the assumption of risk involved in the competitive procedures under government contracting. As I had mentioned before, impracticability and impossibility have merged over time. They don't require a showing of actual literal impossibility, but only a showing of commercial impracticability. So for government contracts, impracticability has been treated as a type of constructive change to the contract, because a commercially impracticable contract imposes substantial unforeseen costs on the contractor, which justifies an equitable adjustment. But again, there's another 4-part test for this legal theory. The contractor has to have had no reason to know the inadequacies of its proposal. Performance under the contract needs to be commercially senseless, which is a case-by-case analysis. The impracticability was caused by a fact that, again, was a basic assumption of the contract, and the impracticability was caused without the fault of the contractor. So this goes back towards the point at the beginning that Jackie was speaking of knowing your supply chains. If you had or should have known that your supply chain falls underneath one of these tariffs and didn't realize it until the costs started showing up on the invoices, well, these theories likely won't be available, because you should have known about that heading into the proposal stage. And then frustration of purpose is probably the most difficult to meet of the three, and this excuses performance by a party where the value of the performance to at least one party and the basic rationale recognized by both parties has been destroyed by a supervening and unforeseen event. One example from some of the tariffs we went over at the beginning is, for example, the tariff with Russia at 200%. If a contract is costing double what it used to, you have a strong argument under commercially senseless or frustration of purpose. And that's going to take us into our avenues of seeking relief.
Yep, so now we want to turn to more of the procedure of, okay, how do we actually go about asking and getting the relief that we need? So there's 3 different avenues. First, if you have a good relationship with your contracting officer, you can just engage in a discussion with them to see where they stand on the issue. You point out the costs that you're incurring, and the basis for why you should think you should get an adjustment, and see what they have to say. They might be willing to work with you on that, get you that adjustment based on that conversation. They may require something more formal, like a change order request or an REA, but we recommend it as a good place to start if you do have that good relationship. Next, there's a request for an equitable adjustment, an REA, which is a less formal mechanism to request an adjustment to a contract, but does not, really start the process toward litigation. And the third avenue that we have here is a certified claim, which really is that first initial step towards litigation with the government. So we're going to talk about the REAs and claims in a little bit more detail. So what are REAs? REAs are methods to obtain additional money, time, or other relief from the government on your contract. So really you can request whatever it is you need. It can be a change in contract terms, it can be additional time, or it can be trying to recover those costs that you're incurring. You can submit an REA anytime during contract performance or closeout, but not after the contract is closed out. So it's very important to keep track of where you are in the contracting process to make sure you don't lose out on that ability to submit an REA. Generally, we recommend that you assert the right to an REA within 30 days of learning the basis of the REA. We've seen there's a lot of notice requirements related to being able to get relief under these various clauses that give the legal basis to get an adjustment. And so, it makes sense to always try to act promptly in terms of providing notice to the contracting officer. REAs are pretty informal, so there's no required format that they need to take. They typically take the form of a letter to the contracting officer with exhibits that provide the backup documentation that details, what the factual background, including, what actually occurred, what costs have you incurred, what the increases are, the impacts to the schedule. So the more detail that you are able to provide in the letter and with supporting exhibits showing the impacts that you're facing, the more likely that the REA will be granted. So it's very important to keep detailed records of your costs and the delay impacts that you face as well, so that you will be able to then incorporate that into the REA. Some of the keys here, so with an REA, you can request reimbursement of attorney fees, administrative costs, and internal costs that you incur in preparing the REA, because the REA is considered more of a negotiation and an administrative cost of performing on the contract. And so the government will reimburse those costs for you. Now, another key is that there is no required deadline for the government to respond to an REA. So that's also very important, thinking about the timing aspect. Because if you need to recover your costs, you need to think about whether you can have those costs be outstanding for a long period of time. If the government takes a long time to get back to you and they don't have a deadline for responding, that can be a downside to submitting an REA and just having it sit out there. Not the case with claims, as we'll see in a minute. So let's hop to the next slide. So key considerations for deciding to submit an REA. How much time is left on the contract? You want there to be sufficient time left on the contract so the REA can be negotiated with the government, or so that you can pursue a claim if the REA route isn't successful. So keep that in mind. How is your relationship with the customer? Like I said, an REA makes sense where you have a good relationship or the issue is less contentious, because it is more of this negotiation process. And hopefully you'll get good traction with the contracting officer. If you don't have that good relationship, that's when it would make more sense to move directly to a claim. How urgently do you need a resolution of the matter? If you need to move quickly, then an REA may not be ideal. Just like I was talking about, there's no deadline for response, and an REA can be sitting out there for a while. What are the issues and how contentious are they? I already touched on that. If it's more contentious, then maybe you want to proceed straight to a claim. And then how strong is your legal position on entitlement? If you have a strong position, it might be able to be resolved through the REA route, because the contracting officer might recognize that and be more willing to negotiate. And with that, I'm going to turn it over to Ryan to tell us a little bit about the claims process.
Sure. So claims are essentially just another method to obtain an equitable adjustment under your contract, and they're the more formal route. So they operate under the Contract Disputes Act. They need to be certified if they're above a certain threshold, and DoD requires certification in most circumstances, even sometimes for their REAs. Claims focus more on more in-depth legal theories, such as all the different types of case law underneath of the changes clause, the various different types of causes of delay, and critical path method analysis. Terminations of your contract would go to the claim stage, whether that's for convenience and the settlement proposal under the termination for convenience hasn't been approved, or a termination for default. That is where you're going to want to head down the claim route to defend the performance and hopefully get the termination for default overturned. The performance evaluations, the results that you get on your CPARs, can be challenged through a claim. And then, of course, just any general interpretations of the terms of your contract is what you can address in a certified claim, such as ambiguities or arguing that the government is misinterpreting the contract. These would all be things that you would want to address under a claim. Now, when it comes to a claim, there is no required format for what the claim needs to look like on the page, but there are requirements for what the claim must include. First, they need to be filed within 6 years after the claim accrues. That's not necessarily 6 years from the date that your contract ends. So again, going back to a point we've been making all along, prompt notice is always recommended anytime something's going to pop up that could cause an additional cost during your performance. It does typically take the form of a letter to the contracting officer, and again, the more exhibits that you have, the better. The claim, if it needs to be appealed, will immediately become part of the record. And so if you have exhibits attached, those exhibits become part of the record too. And the board now has your full side of the story versus the government's right at the outset of any litigation that needs to ensue. The other unique requirement is that there must be a sum certain. For anybody on the call that's been involved in private litigation or civil matters, you can request in excess of or damages approximately totaling. You can't do that with a certified claim. It needs to be some certain amount that the contracting officer has the ability to settle the entire claim for. Claims cannot include attorney's fees. Now, there is a nuance there. If you did go along the REA route first, you can carry the REA attorney's fees into the claim. But once you start working on the claim, those attorney's fees are not recoverable and would have to be later pursued under the Equal Access to Justice Act, which requires its own test and threshold to meet. One of the benefits of a claim is that the contracting officer must issue the final decision within 60 days. However, they do have the discretion, if it's above $100,000, to extend that 60 days. And typically we see extensions between 3 to 6 months. It can be challenged, but it's not an easy argument to win unless the contracting officer, is asking for 3 years or something crazy like that. And then, of course, claims have appeal rights. Like I was mentioning at the beginning of this slide, you can take the contracting officer's decision and appeal that to a board of contract appeals, who will then review that decision, have more of an informal litigation proceeding where the federal rules act as guidance rather than strict adherence. And that's a difference between the Board of Contract Appeals versus the Court of Claims. That's the end result of a certified claim. REAs can't be taken directly to the boards of contract appeals. And so I'm going to let Jackie cover some considerations of REAs versus claims.
Sure. So yeah, just a brief recap of the differences between an REA and a claim when you want to use one versus the other. An REA may be the right first step if you have plenty of time left on the contract, if the issues are not contentious and the customer has signaled openness to the REA, or if it's important to you to be able to include your preparation expenses, including legal expenses in preparing the REA, then it's not yet a dispute and you can negotiate that. Those are all reasons to take the REA route. A claim, on the other hand, makes sense if there's little time left on the contract, or if the contract has ended, then your only option is to file a claim. If the issues are more controversial or your relationship with the customer is adversarial, or they've shown they have no willingness to consider the issue through an REA, or if it's clear that there's already a dispute, so you're not going to get anywhere with them through the REA process, that makes sense to pursue with a claim. And then if you are short on timing where you can't wait indefinitely for the government to respond to an REA, and you need faster action, a faster decision from them, then a claim makes sense as well. Let's see, we got a couple more slides here for Ryan to wrap it up for us.
Yeah, one last thing on the topic of REAs and claims for those on the call that operate primarily as subcontractors. It's important to remember that a subcontractor cannot submit its own REA or claim to the government. You need to get your prime contractor involved, and they have to clearly and affirmatively agree to sponsor your claim to the government. This is referred to as a pass-through claim. You can structure your REA and claim exactly the same as if you were a prime contractor, but it needs to be sent to the prime, who has the privity of contract with the government, to submit that claim on your behalf in order for the government to have the jurisdiction to hear that claim and make a decision as to whether or not you're entitled to relief. FAR 44203C does allow a subcontractor the right of indirect appeal to a board of contract appeals or the Court of Federal Claims, but that's very, very situational dependent and is going to change on a case-by-case basis. Now, final thoughts here, and a word of warning is a strategy that the government loves to use, especially when there's been issues in the performance of a contract, and that's to watch out for any waiver language that you see in modifications or amendments to your contract. They'll often structure this as a closing statement, something to the effect of the modification being in accord or satisfaction of all outstanding delays or monies owed on the contract. Those are items that you do not want to sign. Those waivers may be an absolute bar to recovery. And it's important to reserve your rights if you believe that you need to pursue a claim. Remember, you have a 6-year period to submit a claim. So think way ahead. If you have any inkling of wanting to submit a claim, you do not want to release your rights to do so. And you can negotiate what is in a bilateral modification. If the government issues a unilateral modification with this language in it, it's not binding on you because you didn't sign it. You didn't agree to it. but it's always a good idea, it's always necessary to keep an eye out for this language in any modifications or amendments. And that'll just bring us to any questions.
Yeah, I see one question I want to touch on here. I know we're at the end of our time, so I just want to answer real quick. There's a question about the mandatory FAR clause flow down for prime contractors, whether they need to flow it down. I assume that is referencing the DoD duty-free entry clause where I talked about the mandatory flow down and whether that's necessary for non-commercial firm fixed price subcontracts. If that clause is in your prime contract, then it does need to be flowed down to any subcontractors or suppliers who would be providing the types of products that would be entitled to an exemption as it is identified in the clause. So like the qualifying country and eligible products listed in the clause, regardless of that type of subcontract. I know we're a minute over our time. You see we've got our contact information here. So if you do have a follow-up question, please don't hesitate to reach out to us and we'll do our best to get back to you as quickly as we can. Thank you everybody for your time today. I hope you were able to take away some useful information about how to manage the tariff impacts going forward.
Thank you, everyone.